Welcome to this deep dive. We are thrilled to have you with us today because we are looking at an absolutely fascinating legal collision.
It really is a massive collision.
Right. It asks what happens when ancient, centuries-old common law property rules crash headfirst into the dawn of the computer age. I mean, think about your life right now. You probably have gigabytes of photos sitting in cloud storage, maybe some digital currency or expensive software subscriptions.
Yeah, your whole life is digital.
Exactly. And you consider all of that yours, right?
Right.
But what if someone hacks in and uses your server time? Did they actually steal from you? It sounds like a simple yes, but legally it's a paradox. Can you actually steal something that you cannot even touch?
It is a profound question. And to answer it, we are going to trace a very specific and honestly pretty surprising analytical path today. We will examine a foundational legal doctrine called the strict construction of criminal statutes. Then we are going to break down the precise definitions of how the law views theft.
The old school definitions.
Right. Specifically, common law larceny, statutory grand larceny, and larceny by false pretense. But we aren't just going to look at the theory here. All of this will culminate in dissecting a landmark 1970s case involving thousands of dollars in unauthorized computer use. It really tests the absolute limits of the law.
Okay, let's unpack this. Our specific mission for you today is to dissect exactly how courts handle the theft of intangible services versus physical property, and why that distinction is so crucial. But to lay the groundwork, we need to understand the rules of the game. So, looking at the historical legal standard here, specifically under Virginia law as it applies to our source material, what exactly constitutes grand larceny and larceny by false pretense?
Right.
What did the prosecutors actually have to prove?
Let's lay out the general rules. There are three distinct legal concepts here, plus an overarching rule of statutory interpretation that sort of hovers above everything else. Let's start with the oldest one, which is common law larceny. The classic rule here requires the taking and carrying away of the goods and chattels of another with the intent to deprive the owner of possession permanently.
Just to pause there, goods and chattels is such a specific old school phrase. That basically means physical stuff, right? Like a horse, a pocket watch, a bag of coins.
Exactly, concrete articles of personal property. Next, we move from the common law to the actual written statutes. We have statutory grand larceny. This statute requires either 1, larceny from the person of money, or a thing of value of $5 or more. Or 2, simple larceny not from the person of goods and chattels of the value of $100 or more.
So it's taking that old common law idea of physically carrying away goods and chattels, but attaching a specific dollar amount to it to make it grand larceny.
Precisely. And the third concept is larceny by false pretense. This one is slightly different because it's about deception. This rule has 4 explicit elements you have to meet. First, you must make a false representation of an existing fact. Second, you must do so with knowledge of its falsity. Third, on that basis, you must obtain from another person money or other property which may be the subject of larceny. And fourth, you must do so with the intent to defraud.
That makes sense. Lying to get your hands on someone else's property.
Yeah.
But you mentioned an overarching rule of interpretation that hovers over all of this.
Yes, and this is perhaps the most important concept for our deep dive today. It's the rule of statutory construction. Simply put, criminal statutes must be strictly construed.
Strictly construed, meaning the judges can't just kind of vibe with what the law is trying to say.
Exactly. You cannot stretch the words of a criminal law to cover behavior that the legislature did not explicitly write into the text. If the law says it is a crime to steal a good or chattel, a judge cannot say, well, the legislature probably also meant to include stealing Wi-Fi. The courts take this incredibly seriously to protect citizens from being convicted of crimes that weren't clearly defined beforehand.
Now that we have our rules, I want to introduce the perfect case to test them. Lund v. Commonwealth. The narrative facts of this case are just wild, and they perfectly illustrate this collision between old laws and new technology. So the year is 1974. The defendant, Charles Walter Lund, is a graduate student in statistics and a PhD candidate at Virginia Polytechnic Institute, or VPI.
Which is, of course, a time when computing was drastically different than it is today.
Right. We aren't talking about a MacBook in a dorm room. He is working on his dissertation, which requires heavy use of the university's leased IBM computer. This is a massive mainframe system. But there is a problem. His faculty advisor completely forgets to arrange the proper authorization for Lund's computer time. So what does Lund do? He decides he's just going to use the massive IBM mainframe anyway.
What's fascinating here is the mechanism of his access. To use the computer back then, you couldn't just log in with a password on a screen. An authorized department head had to establish an account, which generated a specific access code. And that code was physically linked to a locked post office box.
Exactly. It was a very physical process. Users would drop off a deck of cards, literally punch cards with their code on it, to be processed by the mainframe. And the physical computer printouts with the results would be returned to these locked boxes. So Lund manages to get his hands on physical keys to post office boxes assigned to other people. He uses their codes, drops off his cards, and takes the results. Over time, he racks up a massive bill. The computer center director estimates Lund used a whopping $26,384.16 in unauthorized computer time.
And we really need to contextualize that number. $26,000 in 1974 is roughly equivalent to over $150,000 today. This wasn't just a minor administrative oversight. He was utilizing a massive amount of incredibly expensive technological resources.
150 grand in computer time. Eventually, different departments start noticing these bizarre, massive charges on their accounts, and Lund comes under surveillance. When an investigator finally confronts him, he initially plays dumb and denies everything, but then, in a very strange turn of events, he admits to it, all while actively trying to hide one of the stolen post office box keys inside his sock. Investigators then search his apartment and find a massive hoard of computer cards and printouts.
The visual of him trying to stuff the key into his sock while confessing is incredible. But we should also note the academic fallout from all this, or rather, the surprising lack thereof.
That might be the craziest part. Despite these pending criminal charges for stealing tens of thousands of dollars in computer time, 4 of his faculty advisors actually testify on his behalf. They essentially say, well, he would have been approved for the time if he had just asked properly. The academic committee even awards him his PhD while he is literally facing trial for grand larceny.
It is an incredible set of events, but it leaves the court with a very thorny legal problem.
Right, let's analyze Lund v. Commonwealth. First, what are the legally dispositive facts?
The essential facts are that the defendant used a university-leased computer without authorization. He utilized physical keys and access codes belonging to other people to do this. Through this unauthorized use, he generated physical computer cards and printouts. The computer time itself was valued at over $26,000, but the physical printouts were valued by the university only as scrap paper.
And what was the core legal issue?
The precise legal question is this. Can the unauthorized use of computer time and services, or the obtaining of printouts with no ascertainable market value, constitute goods and chattels or property subject to larceny under the grand larceny or false pretense statutes?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the statutory rules for grand larceny and false pretense, governed by the overarching rule that criminal statutes must be strictly construed. For the prosecution to succeed in this context, the rule has 2 primary testable elements. First, the subject of the theft must be a concrete article of personal property, a good or chattel capable of being taken and carried away. Second, specifically for grand larceny, that specific physical property must be proven to have a value of $100 or more.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the requirement of goods and chattels?
Let's look at the sub-issue here. Is unauthorized computer time and labor a good or chattel subject to larceny? The sub-rule dictates that because criminal statutes are strictly construed, goods and chattels requires a concrete article of personal property that can be taken and carried away, not merely the use of a facility.
So how do they apply that to Lund?
The court looked at the statute and noted the word use appears nowhere in it. The defendant merely used the computer services and labor. He did not take and carry away a concrete article when he utilized the IBM machine. Therefore, the conclusion for this element is that computer time and services fail the first element and cannot be the subject of larceny.
Understood. Now, what about the second element, the $100 value requirement applied to the physical printouts and keys?
The sub-issue for the second element is whether the physical items taken, the keys, the cards, and the printouts, possessed a provable value of $100 or more. The sub-rule here is that where an article has no market value, its actual value must be proved. Crucially, the cost of labor and services to produce the item is not the proper criterion for its value.
So they couldn't just use the $26,000 computer bill.
Exactly. In applying this, the court noted the Commonwealth tried to argue the printouts were worth $5,000 based on the cost of the computer labor to generate them. However, the computer center director admitted the physical printouts were worth nothing more than scrap paper to the university once printed. Furthermore, any academic value to the defendant himself was pure speculation.
So what was the conclusion for that element?
Because actual value could not be proved to be $100 or more, this second element was not met.
And after analyzing all the elements, what was the court's final conclusion?
The ultimate holding was that the court reversed the conviction and quashed the indictment. Because the unauthorized use of computer time is not a tangible good or chattel, and the physical printouts had no ascertainable monetary value beyond scrap paper, the evidence was legally insufficient to convict the defendant of grand larceny or larceny by false pretense.
Here's where it gets really interesting. I want to make sure you, the listener, truly grasped how rigid this common law logic is. Because hearing that someone walks away after intentionally using $26,000 of someone else's resources feels deeply wrong. Could you give us a visceral, unforgettable hypothetical to lock in this counterintuitive legal distinction between using something extremely valuable and actually stealing a good or chattel?
Absolutely. Imagine a rogue employee sneaking into a highly specialized, multi-million-dollar meat processing plant at midnight.
Okay, set in the scene.
They bring in their own legally purchased raw mystery meat. They turn on the factory's massive, expensive industrial meat grinder. They proceed to use thousands of dollars worth of the factory's electricity and mechanical wear and tear to grind their mystery meat into sausage. And then, before the sun comes up, they simply leave with their freshly ground sausage.
Oh, that is incredibly gross, just showing up with your own mystery meat in the middle of the night.
Yeah.
But I see where you're going with this. They undeniably used incredibly valuable machinery, labor, and electricity without permission.
Right. But under the strict common law definition articulated in Lund, did they commit larceny of goods and chattels? No. They didn't take and carry away the meat grinder itself. They didn't steal the factory's physical meat. They just used the facility.
It seems like I must have stolen something, the electricity alone.
If we connect this to the bigger picture, it perfectly illustrates how rigid and physical the common law definition of larceny truly is. The law was designed centuries ago to punish someone who steals a horse, or a bag of grain, or a physical tool. It simply was not designed to prosecute the unauthorized use of another person's highly valuable equipment or time.
So what does this all mean? We have journeyed from the strict letter of Virginia Code through a graduate student's unauthorized IBM binge and finally to a rogue midnight sausage operation. If you want to spot these legal loopholes in the wild or just understand how the law struggles with modern problems, how do we distill this complex doctrinal analysis into an actionable tool?
If you want a mental framework to view these kinds of legal collisions, you really just need to follow a 4-step diagnostic checklist for issue spotting and structured analysis. Step 1, identify the nature of the property taken. Is it a concrete physical article, a good or chattel, or is it an intangible service, labor, or unauthorized use of machinery?
The tangible versus intangible test.
Exactly. Step 2, apply the rule of strict construction. If the statute defines larceny as taking goods and chattels, you must strictly construe that to exclude mere use or services, no matter how much monetary value that use holds. You cannot stretch the words.
Got it. What is step 3?
Step 3 is perform the value diagnostic. If physical items were taken like paper printouts, isolate their actual or market value. Do not conflate the cost of the labor or services used to produce the item with the value of the item itself. The labor cost is entirely irrelevant to the statutory value of the good.
And the final step.
Step 4 is check for alternative charges. Recognize that while traditional larceny might fail, this points to a gap in the law, not necessarily innocence of any wrongdoing. Today, we have entirely new, specific computer fraud statutes to close these gaps. But under pure common law, the gap is wide open.
That mental framework is an absolute lifesaver. You really have to keep the physical object completely separate from the invisible service in your mind. And that leads me to a final thought for you to take away from this deep dive. Charles Lund literally got away with stealing what would be $150,000 today in computing power, simply because the laws of 1974 couldn't comprehend stealing something you couldn't touch. Think about your entire digital life today, your cloud storage, your server processing time, your digital assets. If the law must be strictly construed, how much of our modern world is completely invisible to ancient common law? It is a fascinating collision of history and technology, and definitely something to mull over until our next deep dive.